Evening, Mayor Pro Tem, members of the council, Deputy City Attorney Jason Zaragoza, presenting on behalf of the Office of the City Attorney on no fault, just cause eviction ordinances, an urgency ordinance, and a regular ordinance. So the recommendations before you are to adopt an urgency ordinance regarding no fault, just cause evictions occurring as a result of a demolition or substantial remodel. The second recommendation is to approve the first reading by title only and waive further reading of an ordinance that does the same thing, amends the city code regarding no fault, just cause evictions occurring as a result of a demolition or substantial remodel. And then the third recommendation is find that the ordinances are not subject to CEQA and are further and independently exempt from CEQA as well. All right, so tenant protections. Under the Tenant Protection Act of 2019, also known as Assembly Bill 1482, owners of residential real property are prohibited from terminating a tenancy without just cause, subject to certain narrow exemptions. One of those narrow exceptions is in order to substantially remodel a rental unit. And substantially remodel in both state law and in the Oxnard City Code is clearly defined as the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a governmental agency, or the abatement of hazardous materials. It's important to note that the definition also includes the fact that these substantial remodels cannot be reasonably accomplished in a safe manner with the tenant in place, and that require the tenant to vacate the residential unit of real property for at least 30 days. Both state law and the city code are also specify that a cosmetic improvement alone, so something like painting, decorating, doing minor repairs, they don't qualify as a substantial rehab. There are loopholes in AB 1482 and by extension, the city's ordinance that have led to abuses that leave some covered renters vulnerable to displacement or eviction, where in essence, you have a property owner that terminates a tenancy under the guise of doing a substantial remodel, even when the owner doesn't have an intent to actually perform a substantial remodel. So without more protective local just cause eviction provisions, substantial remodel evictions that don't actually qualify as substantial remodel would result in displacing tenants, some of whom may become homeless. So an urgency ordinance under Government Code Section 36937, subdivision B, is authorized when there's an immediate issue to preserve public peace, health, or safety with a 4/5 vote of the city council. So for a 7-member council, that would require an affirmative vote by 6 members of the council. And if adopted, the ordinance is effective immediately. So the urgency findings are in the staff report and in the ordinance. They include but aren't limited to the city experiencing a housing affordability crisis and a homelessness crisis. The city's also received no fault just cause eviction notices and threats of eviction due to purported substantial remodeling of residential properties where permits haven't been sought to undertake the work. So city having received those complaints from tenants and adopting a regular ordinance without an urgency ordinance to fill a potential gap in time could have the unintended consequence of temporarily prompting more substantial remodel evictions. State law allows the city to adopt additional tenant protection regulations if they're more protective than the provisions of AB 1482. So if adopted, the ordinance would provide additional tenant protections by requiring a written notice terminating a tenancy for just cause to include all of the following. So this is where an owner is terminating a tenancy in order to perform a substantial remodel or a demolition. So in the notice, they'd have to include a statement informing the tenant of the owner's intent to demolish the property or substantially remodel the rental unit. And then the following statement. So if the substantial remodel of your unit or demolition of the property as described in this notice of termination is not commenced or completed, the owner must offer you the opportunity to re-rent your unit with a rental agreement containing the same terms as your most recent rental agreement with the owner at the rental rate that was in effect at the time you vacated. So there's a lot to unpack there. But in essence, it's a notice that one describes the substantial remodel or demolition and requires the owner to offer the tenant to re-rent the unit at substantially the same terms as the most recent rental agreement that was in effect at the time of the vacation. And then there's the next piece of it. You must notify the owner within 30 days of receipt of the offer to re-rent of your acceptance or rejection of the offer. And if accepted, you must reoccupy the unit within 30 days of notifying the owner of your acceptance of the offer. So that's the timely requirement that is then on the tenant to either accept or reject the offer. The owner would also have to provide in the notice a description of the substantial remodel to be completed, the approximate expected duration of the substantial remodel, or if the property is to be demolished, the expected date by which the property will be demolished, together with one of the following. And these are requirements to ensure that the owner is actually undertaking the work. And they'd have to provide a copy of the issued permit or permits required to undertake the substantial remodel or demolition. And if the remodel doesn't require any permit, then a copy of a signed contract with the contractor hired by the owner to complete the substantial remodel that reasonably details the work that'll be undertaken. So again, the whole point here is to ensure that permits are actually being acquired and that a substantial remodel is actually occurring in order for this no-fault just cause eviction to occur on the grounds of performing a substantial remodel. And then the fourth piece of that is a notification that if the tenant is interested in reoccupying the rental unit following the substantial remodel, that the tenant must inform the owner of the interest to reoccupy and provide the owner to the owner the address, telephone number, and email address to contact the tenant. So the non-urgency ordinance, or the standard ordinance that's before the council recites what is in the urgency ordinance minus the urgency findings. So if presented to the council January 25th and then introduced on that date, it would then be presented for adoption on February 6th, 2024. And then if adopted, the non-urgency ordinance will become effective 30 days thereafter. And then with that, we would take questions. Thanks.